Good morning. I want to ask all of us to please turn our cell phones to silent. You may notice board members accessing their Dr. Howard's request electronic devices. Actually, we have so many places rather than just laptops. During the meeting, they're using these devices to access the board meeting materials that are in electronic format. This is an official meeting of the Medical Board of California. As such, disruptions of the board's business will not be tolerated. We have designated time on the agenda for public comment and ask for the public comments on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct him or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press *1. You will hear a tone indicating you are in the queue for comment. If you change your mind, do not want to make any comment, please press *2. Assistant is available throughout the teleconference meeting. To request a specialist, press *0. Each person will be limited to 3 minutes per agenda item. During the agenda item 13, public comments on items not on the agenda, board has limited the public comment period for individuals on the teleconference to 20 minutes. In addition, the public comments from individuals here at the meeting will also be 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on the agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. I would like to request all speakers complete a presenter slip so I can call on you by name at the appropriate time and the record of this meeting can be full and complete. However, this is voluntary. Please give slips to Ms. Cruz Jones. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make a last-minute comment. We'll plan to end the meeting definitely before 2 p.m. I would like to call the meeting to the order and ask Ms. Cruz Jones, please call the roll call.
Dr. Bolat?
Present.
Dr. Hawkins?
Here.
Dr. Kraus?
Here.
Ms. Lawson? Dr. Levine? Dr. Lewis?
Present.
Ms. Pines?
Here.
Ms. Sutton-Wills? Mr. Warmouth?
Here.
Ms. Wright? Dr. Yip?
Here.
Dr. Gonadev?
Here, the quorum is present. I would like to remind the members again that we'll be taking roll call and vote on all action items. Moving to agenda item 13, public comments on items not on the agenda. I have 2 slips. First one is Tim Smick. Mr. Smick, come on, please. Okay. Tim and Tammy Smick. Thank you.
If it's okay, I'll go first. Ms. Webb, before you start the timer, I do want you to Tammy Smick. My husband and I flew here from Los Angeles to speak to you personally. The mission of the medical board is to protect healthcare consumers, but in the case against Dr. Daniel J. Hedrick, you have failed miserably. Your website states that death cases are given priority, but the complaint I filed against Dr. Hedrick took more than 4 years to reach a decision, and it took the medical board investigators 2 years after I filed my complaint to even interview Dr. Hedrick. My son, Alex Smick, went to Dr. Hedrick's facility to safely detox off of prescription pain medications. However, within 2 hours of arriving at Dr. Hedrick's facility, Alex was started on a lethal combination of medications. Dr. Hedrick wrote an order to check Alex's vitals only while awake. So the first night under Dr. Hedrick's care, Alex was left unmonitored for more than 7 hours without even one blood pressure check. When he was finally checked on during morning rounds, Alex was found dead. He was already in rigor mortis. My son had been seizing, vomiting, and fighting for his life after being given Dr. Hedrick's poisonous medications, but nobody came to help him because of Dr. Hedrick's orders. Nearly 3 years after I filed my complaint, an accusation was filed against Dr. Hedrick for repeated negligent acts resulting in Alex's death. Dr. Hedrick's license on the medical board's website even said, "Accusation filed, petition to revoke." I was relieved, thinking the medical board would revoke Dr. Hedrick's license and prevent him from killing another innocent patient. But in a confidential settlement hearing, a bargain was reached. I was told the stipulated settlement was confidential, and I would only be told the terms of the settlement once the medical board approved it. But I was certain that at minimum, Dr. Hedrick would be put on probation and have to take classes to learn about medications and monitoring so that other patients would be safe from his dangerous practice. But on December 21st, just a few days before this last Christmas, I received an email from the medical board saying a decision had been reached. I had to weed through a 16-page legal document to find the board's decision. I was shocked and outraged, literally brought to my knees. I felt as if a knife were piercing my heart when I read the words, "public reprimand." How can you allow a doctor accused of over-medicating a patient to death to get away with a slap on the wrist? Your job is to protect the public, not protect dangerous doctors. 42 years ago, the governor signed MICRA, the Cap on Pain and Suffering, into law with the promise that the medical board would be there to protect the public. But because of MICRA, you have an extra duty to protect us, and you are failing terribly. Shame on you. Shame on all of you.
We entrusted Dr. Hedrick with Alex's care, and his negligent acts killed our precious son. Excuse me. Do you have any idea what it's like to be taken to your son's hospital bed and to see his purple body with his arms above his head? Do you know what it feels like to feel your son's cold flesh? To try to move his arms down only to discover they are frozen from rigor mortis. That was Dr. Hedrick's actions. I cannot begin to tell you how appalled I am with the medical board's handling of our complaint. We trusted you to do the right thing, and you too have failed us. We went to the police and were told that the medical board would take care of it. We filed a lawsuit, but our access to justice was blocked by MICRA, the outdated cap on pain and suffering, and a CMA board member told us the medical board would handle it. So for more than 4 years, we waited for you to take action against Dr. Hedrick, and you did nothing more than give him a public reprimand. The Attorney General's accusation included sufficient allegations to revoke his license or at least rehabilitate him so he couldn't kill another patient. But you chose a confidential, secret deal. Pathetic. We are Where is the accountability? Where is the incentive to change? Hedrick is not deterred by any California law, and because of that, patients continue to be put at risk. His future patients will likely never know what he did. You had a chance to stop him, and you didn't. The next time Dr. Hedrick kills a patient, the blood is on your hands. Thank you.
Thank you, Mr. and Mrs. Smith. We do feel your pain. I do want you to know that if you need any details on that, maybe you can talk to one of our staff members. We do have two panels. Each panel evaluates and comes to a decision. It's very thorough process. It's mostly, more than anything else, is the expert opinions on the side of the doctor and the side of the medical board. And that's what makes a decision, what the experts think, if the quality of care was met or was not met, or egregious or gross negligence or simple negligence. So there are a lot of issues come into play. Board is the last one to look at, but there is a process which goes through, and my goal is to get this 4-year timeline cut down to somewhere where it is really, especially bad doctors practicing, will be taken out of service. And some good doctors whose good name is in a bad place, that is taken off both ways. So it goes both ways, but more than anything else, we want to make sure that no patient is harmed while our investigation is going on. Thank you for coming, though. We truly appreciate it. Any public comment from the audience here? Public comments on the phone?
We have a comment from Susan Lauren. Your line is open.
Hello. I request that my case be reopened and the license of the surgeon who clearly and severely mutilated me be permanently revoked in the interest of public safety. Clearly, your experts need to be replaced because, recall, I was medically recommended to breast reduction as a solution for pain. I didn't go to surgery for weight loss. I was healthy and muscular and worked out daily. Doing lipo was wrong patient selection. I was fit and petite with skin ptosis. The board-certified plastic surgeon referred to me by my PCP, destroyed my breast, and used power-assisted liposuction, a risky modality I didn't approve of. He littered over 60% of my body with dozens of unexpected, unsutured wounds into muscular zones. He removed wanted, needed body parts while I was unconscious. His actions were not medically justified. His egregious sculpting trip and cover-up shows obvious evidence of gross negligence and depraved conduct. I awoke from surgery convulsing, disabled, disfigured, and in horrific pain, and entered a world of denial and slander. The surgeon's records are inept and fabricated. His wife is his office manager. There are no checks and balances. His office is not accredited. Before surgery, I was a thriving business owner, attractive and very careful with my health. I didn't agree to look worse naked, but that's the absurd defense rebuttal to this full-body mutilation, which surgeons say exceeds all semblances of sanity. Last October, my speech was buzzed over at 2 minutes. Yesterday, my call was erroneously cut off. Christina Delt now sends Shield aside if the investigation warrants reopening. This negligent surgeon ought to have been defrocked based on the original complaint. The way this has been dealt with is a vile abuse of power. Nobody in his or her right mind would excuse or mitigate these intolerable violations. Litigation was used to antagonize, victim blame, skin shame, and slander me. The surgeon's attorney assassinated my character with lies, tried to silence me with an under-limits gag clause, and gagged me after trial, which he then billed me for. The defense hired a very pricey TV surgeon who reviews cases for your board. In deposition, while discussing my mutilation, he made jokes about how much money he makes. He has scathing reviews. He lied in court saying I don't have a buttocks due to natural causes when it was actually removed via surgical mischief. He left me at risk for homelessness, and via the endorsement of your board, the jury listened to him. Again, I request you do the right thing for public safety, do your duty, and permanently revoke the license of the surgeon who mutilated me, committed fraud, staged a criminal cover-up, and shows no remorse. those who deny or defend this atrocity are responsible for harm to future patients and give dangerous carte blanche to surgeons. Don't thank me for this. The way you thank me is by doing the right thing. And Gurudev, you do not feel my pain unless you have had this surgeon stick a power tool into your body while you were unconscious and remove parts of your body. I am in excruciating pain every single day. I'm being slandered for it. Your board has done nothing. Do you feel that pain? Because, I'm really offended. I just listened to the testimony of the parents.
Ma'am,
and
please
I was
conclude.
crying, and I do not hear compassion. I can't believe how you're failing the public.
Please
And
conclude.
outrage. It's an outrage. Now, you still have time to do the right thing about this surgeon, and I expect you to.
Any other comments?
Do we have any other comments on the line?
We have a comment from Rose Nyland. Your line is open.
Thank you. My comments today are about liposuction and other fat-removing procedures. 11 years ago, I went in for a slight breast reduction and felt pressured into having liposuction done as well. I went to a well-respected board-certified surgeon, and she took a conservative amount of fat from my breasts and abdomen. I sailed through the surgery, but the long-term negative effects are still with me and will certainly last a lifetime. As a registered nurse and a fierce researcher, I have concluded that adipose removal is harmful for many reasons. I will highlight 2 reasons today and follow up with others in subsequent meetings. Number 1, fat redistribution. Removal of fat from one body depot causes fat to increase in non-treated depots. This phenomenon is consistently reproducible in animal studies and is basically accepted as fact among animal researchers. Cells in non-treated depots both multiply and hypertrophy, apparently as a compensatory mechanism. In my case, I've noticed increased fat all over, but since I'm an apple shape, the weight gain is especially noticeable in the upper body, i.e. the face, arms, and back. Within months after the procedure, I looked fatter simply because the part of my body more on display was bigger. I know we patients are supposed to have realistic expectations, but I think it's reasonable to expect that the procedure not make you fatter. This reaccumulation of fat has resulted in 2 other problems for me. My thighs are always sore to touch in certain areas, and one doctor diagnosed me with post-liposuction lipedema. Not all doctors would agree with this diagnosis, but I know that it's not normal to have chronic soreness in my legs, and I suspect that it is due to fat that has grown in a disordered way. I also experienced chronic bursitis in approximately 30 different body areas. One doctor told me that the weight redistribution may have altered my body mechanics, resulting in bursitis. Additionally, and very importantly, one study showed that the fat reaccumulation occurs in the visceral organs, which, as you know, has many negative consequences, including an increased risk for cardiac disease, stroke, hypertension, diabetes, and cancer. It's not sensationalizing to surmise that this procedure has probably shortened my life. The second point is fat is an organ. Fat removal worsens a person's health because the, quote, tissue that is being removed is actually part of an endocrine organ that performs essential body functions. A recent human study showed that the triglyceride levels of liposuction participants increased as compared to a control group. It is theorized that fat plays a positive role in metabolism and acts as a metabolic sink to sequester triglyceride and perhaps other constituents.
Ms. Nylon, please conclude.
In conclusion, for these and other reasons not yet discussed, liposuction is a harmful procedure that does the opposite of its claim and may even shorten the human lifespan. Thank you.
Thank you. Any other comments?
We have a comment from Eric Andrist. Your line is open.
Good morning, it's Eric Andrist. I'd like to give a shout out to some of the victims of the medical board who are in the audience today in person and watching on the telecast, and the members of the press who are tuning in today, especially today, since Carrie Webb, staff attorney, is going to finally explain how the disciplinary guidelines work. I'm now going to talk about a closed case that will relate to Carrie's later presentation. In 2004, Dr. Marvin Derrick failed to drain a massive pericardial effusion, which resulted in the death of that patient. Then in 2007, he left a surgical sponge inside one patient, and in 2008, 2 surgical sponges were left inside another. In his accusation, it is written, respondent's failure to confirm the final sponge counts prior to wound closure in these 2 surgeries and the failure to dictate notes confirming that the final counts were correct constitute repeat acts of negligence by respondent. His failure to drain the massive pericardial effusion constitutes gross negligence and an extreme departure from the standard of care. Now, does anyone want to guess what the medical board in all its patient safety wisdom decided his discipline was? Shall we open up the guidelines, Carrie Webb, staff attorney, and see what it suggests for harm to 2 patients and death of another? So as to not waste time, I'll just tell you. He got a public letter of reprimand with the unusual stipulation that he was to retire within 10 days. He actually signed and agreed to that. Odd thing is, he signed that agreement in 2011, and yet 7 years later, he still has his California license and is practicing in Decatur, Illinois. He never did retire. So when you talk about uniformity, consistency, and fairness in your presentation, Carrie Webb, staff attorney, make sure you explain how a doctor who killed a patient and left foreign objects in 2 others and promised to retire got a public reprimand and then didn't retire. You just heard about how the medical board treated Tim and Tammy Smick's case so horrendously and gave the doctor that overdosed their son to death a public reprimand. We are amassing a huge treasure trove of these cases that prove that the Medical Board of California is simply not doing its job to protect the citizens of this state from bad doctors. Cases like Annette Ramirez, whose negligent doctor left her with all 4 of her arms and legs amputated. You know what you did with her complaint? You closed it without investigation. Same for police officer Robert Downey, who lost all 4 of his limbs because a doctor was negligent. Or triathlete Mario Guzman, whose doctor failed to order a simple test and that led to all 4 of his limbs being amputated. And when Marion Hollingsworth's father, who was a beloved dentist in San Diego, was killed with chemical restraints by a negligent and uncaring doctor, you plea bargained his death charges away and slapped the doctor on the wrist with a public letter of reprimand. Your 4% disciplinary rate is simply unacceptable, and more people are stepping up every day to say that we are not going to stand for it any longer. Soon, we are going to be calling for an audit of this board by the state auditor and or the Little Hoover Commission. So fasten your seatbelts. It's going to be a bumpy ride. And Dev,
Please conclude.
Don't stop pretending that you know these people's pain and suffering. Hedrick's case was decided by an attorney general person. And stop interrupting. By an attorney general person who stipulated his death charges that your
Any other comments on the phone?
There are no more comments on the phone.
Thank you. We're skipping 14. She's here. Let's move to the next agenda item, which is number 14, a presentation on the Stephen M. Thompson Loan Repayment Program. I would like to ask Ms. Asprek to come forward. Ms. Asprek is the Executive Director of the Health Professions Education Foundation. Her full bio can be found in the agenda item 11-1. Ms. Asprek.
Good morning, Mr. Chair and board members. My name is Norlin Asprek. Apologize for my voice. I am the Executive Director for the Health Professions Education Foundation, and I'm pleased to be here to share information in regards to the Stephen M. Thompson Physician Corps Loan Repayment Program. I can keep going while we'll skip that. Let me just continue. So just overview of the Health Professions Education Foundation. We were created in 1987. We are a 501c3 nonprofit that is housed within the state. We're housed within the Office of Statewide Health Planning and Development. And our mission is to improve access to healthcare in underserved areas of California by providing financial incentive awards in the form of scholarships and loan repayments to health professional students and graduates who are dedicated to providing direct patient care in those areas of unmet need. The Health Professions Education Foundation, also known as HPEF, administers 6 scholarships and 7 educational loan repayment programs available to health professional students and graduates who are willing to provide medical and mental health services in underserved areas of California. Since our inception in 1987 to present, we have awarded over 14,000 individuals, and our award amounts have totaled $169 million. In fiscal year 16-17 alone, we have awarded 1,839 individuals with a total amount awarded of $22.9 million, and that was as of June 30th, 2017. In addition to the Stephen M. Thompson Physician Core Loan Repayment Program, we provide scholarships and loan repayments for professionals that are in allied healthcare, vocational nursing, registered nursing, advanced practice clinicians such as nurse practitioners and physician assistants, licensed mental health professionals, and such as social workers and marriage family therapists. For our award criteria, all of our programs have a culturally competency component, and our eligibility and scoring are based on the following criteria, which includes academic performance, the applicant's community background and life experience, their cultural and linguistic competency, their career goals, their financial need, their place of employment, and the number of hours that they work per week. When an awardee does sign a contract with us, they are required to fulfill a service obligation that's between 1 to 3 years. And in regards to compliance, these individuals must submit a progress report to us every 6 months. Some of the underserved areas in which our recipients work are in qualified facilities with the county, state, correctional facilities, Veterans Affairs, medical centers, and Indian health centers. And some of our programs do require a federal designation, such as the medical underserved areas, or MUAs, health professional shortage areas, primary care shortage areas. For our nursing programs, registered nursing shortage areas, and for those that are working in FQHCs, those are facilities that qualify, as well as rural health clinics. Our Stephen M. Thompson Physician Core Loan Repayment Program application cycle is currently open. The deadline to apply is January 31st, and applications can be accessed online via CalReach, and the link is listed on this page. So going into more detail on the Stephen M. Thompson program, which was originally housed under the medical board, the purpose of this program is to increase the number of culturally and linguistically competent physicians throughout California that are in medically underserved areas. This program is funded by the $25 licensing fee from the medical board, as well as the Osteopathic Medical Board of California. We do receive $1 million from the Managed Care Administrative Fines and Penalty Fines. And we also received, and we completed this grant, but we did receive funds from the California Endowment for this program, totaling $4 million. The award amount that the recipient would receive is up to $105,000 in exchange for 3 years of service. 65% of our funds are given to primary care doctors. 15% is directed to those that are working in geriatric settings, and no more than 20% of our funds go to physicians that are working in specialty. Who can apply to this program? Any doctor with an MD or DO license is eligible to apply. Both primary care and specialty care are eligible. In terms of the hour requirement, we do require a minimum of 40 hours per week with 32 hours of direct patient care. For those that are OBGYN physicians, there's a minimum of 40 hours per week with 21 hours of direct patient care. And the applicant must have educational loan debt. Some of the common primary care specialties that we award are family medicine, internal medicine, pediatrics, and OBGYN. Other specialties outside of primary care is surgery, psychiatry, emergency medicine, and gerontology. In addition to the application, we do require that the applicant fill out a certification of practice setting form by their employer, which just confirms that the applicant speaks a Medi-Cal threshold language in their work setting, and that they are meeting the number of minimum hours that they're working at their work site, as well as the number of direct patient care hours. And this map just gives you an overview of our 16-17 cycle of all the awardees that we've awarded. We awarded 91, and they are all the counties are shaded of where the recipients are working. And if you'd like to connect with us, we are on Facebook and Twitter, and my contact information is there if you'd like more information. You can view it on our website.
Thank you, Ms. Asper. Any members have any questions? Yeah, Ms. Wright.
Since you are housed within the state, what type of fundraising do you do, and are there restrictions to the type of fundraising you can engage in? Like, what do you do to get money? Because I this is the first time I've ever heard of this, so I just would like to know more. And then secondarily, what kind of outreach do you do to get students or doctors to apply to the program?
That's a good question. Our board is very focused on fundraising, and since we're uniquely situated under the state, our 501c3 status is what gives us the flexibility to obtain grants and donations. So in 2013, we received a grant from the California Endowment. So that is one of the forms of grant funding that we've been able to obtain. We've also received grants from California Wellness and Kaiser. And we're wrapping up our Cal Wellness grant, and we just received our Kaiser grant for our licensed mental health program. In regards to individual giving, we did launch our first annual alumni giving back to HPEF, and we reached out to former recipients, and some of which are former Stephen Thompson recipients that have donated back to the organization. In regards to outreach, we are active in our partnership with USC Medical School and their primary care department, as well as the UC Medical Schools. We've reached out to all of the deans to promote the Stephen M. Thompson program, and we are also very active in going to health professional fairs.
Dr. Cross.
Thank you very much for this update. The state and the medical profession has recognized underserved communities and a need to help those communities in particular. And the Stephen Thompson Loan Fund has been an avenue to improve the availability of care in these communities. The board does have a history of having been very active in support of this fund, and even was active in the administration for a number of years. Periodically, the board has included in the newsletter information about the
Yes.
Stephen Thompson Fund, and will continue to do this. So everything we can do, we will do to get the word out, so that physicians can take advantage of this, because it helps the underserved. Thank you.
Thank you. And I've shared that information with my board too, so we appreciate it.
Thank you. Dr. Yip.
Thank you. I see that the applicant from Federal Qualified Health Center also qualify applicants if they happen to be located in LA County, for example. Are they still qualify for that loan?
Yes. Yes, they would qualify.
Any comments from the audience? Comments on the phone?
We have a question from Shalina Garez. Your line is open.
Go ahead, please.
Shalina, your line is open.
Okay. Any other comments?
There are no further questions.
Thank you. Thank you, Ms. Asper.
Thank you.
Now moving on to the next item, which is agenda item 15, discussion on possible action on appointment of members to the Health Professions Education Fund. Based upon the member interest in the foundation, it's the recommendation that Ms. Lawson and Ms. Sutton-Wales be appointed to the HPEF as the two members from the board for 2 years. If others are interested in being on the foundation, there will be another opportunity at the end of that period. Can I have a motion to appoint Ms. Lawson and Ms. Sutton-Wales to the Health Professions Education Foundation? Okay, any further comments? Comments from the audience? Comments on the phone?
We have no questions in the queue.
Thank you. Ms. Cruz-Jones, roll call, please.
Dr. Bolott? Aye. Dr. Hawkins?
Yes.
Dr. Kraus? Yes. Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Mr. Wormuth?
Aye.
Ms. Wright? Dr. Yip? Dr. Gonadev?
Aye, the motion carries. Moving to the next item, which is 16, presentation and discussion on the disciplinary guidelines and the board members' role in the disciplinary process. Ms. Webb.
Good morning, everyone. Thank you for letting me speak with you today and give you a refresher on our disciplinary guidelines and a suggested approach to reviewing cases. So, we know that the board's priority is consumer protection in all of the board's functions, from licensing to discipline. Whenever there is another consideration to think about, public protection is paramount. When the board or the administrative law judge exercises its disciplinary authority, whenever possible, they are instructed to take action to rehabilitate the physician. However, if rehabilitation and public protection are inconsistent, public protection is paramount. The goal of discipline is consumer protection, not punishment. And what happens if the board revokes a license or administers a term or condition that is not consistent with the evidence is that gives the physician grounds to file a writ with Superior Court. That case then comes back to the board to revisit its decision and many times to strike or completely reverse the discipline imposed. So the purpose of the disciplinary guidelines, there's several. It assists the board in evaluating the cases. It helps foster uniformity and hopefully it acts as a deterrence. It provides a framework for reviewing cases and letting licensees know what to expect if they're considering violating the Medical Practice Act. The disciplinary guidelines were drafted by the board and staff with input from stakeholders. They always go through the customary rulemaking process, so it's very open. People can comment, make suggestions that have to be responded to. They're formally incorporated into the board's regulations, and they're amended as needed. We're on our 12th edition currently. The way they're structured is they contain model orders. They're organized by code sections that are violated. They show maximum and minimum suggested levels of discipline, and they have standard conditions that appear in virtually every decision, and also optional conditions that are tailored again to the public protection and rehabilitation of the physician depending on the facts of those cases. The guidelines are applicable to both proposed decisions and stipulations, and so everyone knows a proposed decision is written by an administrative law judge after a formal hearing. And a stipulation is an agreement reached between the parties after negotiations before hearing, and this often involves input from the administrative law judge. There are differences between proposed decisions and stipulations. A proposed decision results, again, from a full administrative hearing where people come to testify. There's vigorous cross-examination from the attorneys involved, and the administrative law judge can consider the credibility and the manner in which people testify to weigh into their decision. And a stipulation, again, is a proposed settlement between the parties that is designed to avoid delay, uncertainty, and also expense. Both proposed decisions and stipulations must consider and use the guidelines when determining the appropriate discipline, but the proposed decision must state the reasons for the deviation from the guidelines, but a stipulation does not. And often the question we get is why? It's difficult for individuals who see a stipulation to understand how it's possible that the board concluded the stipulation was appropriate. But the settlement discussions are confidential, and this is required by law. It's designed to promote a speedy resolution without the need for a hearing. And the board members get a DAG memo, a Deputy Attorney General memo, that explains why the stipulation is being proposed and the justifications for deviating from the disciplinary guidelines if that is what happened. If there's not a settlement, neither party can disclose the motivations for attempting to reach a settlement. And it's the confidential nature of these discussions that promote frank conversations during the settlement process that allows for the review of the strengths and weaknesses of the case to reach a decision that will protect the public and rehabilitate the physician where appropriate. Settlements would be very difficult to reach if these confidential communications became part of the case during an administrative hearing. So there's many ways to review cases. Here's a suggested way to approach it. That you review the accusation, and something to be aware of about accusations is that the charges that are in there are there because there's a belief that there is support to be able to prove those charges by clear and convincing evidence if the matter were to go to hearing. Those charges are there prior to receiving the respondent physician's expert report. That does not come until later during discovery. That can change what the ultimate charges will be able to be proven. So you read the accusation, you note the allegations, you read the proposed decision, and you determine what, if any, allegations have been sustained. You want to have confidence that the decision used the correct standard of care, which is clear and convincing evidence, far above the preponderance of the evidence that's used in civil court. There has to be evidence cited to support each conclusion based on the information noted in the factual findings of that proposed decision. You review the disciplinary guidelines to determine what they suggest for each violation of the Medical Practice Act, and you determine whether the discipline ordered follows the guidelines for each violation. If it doesn't, does the proposed decision provide adequate justification for the deviation? You determine whether the proposed discipline provides sufficient consumer protection, and where possible, and when it's not inconsistent, rehabilitation of the physician. And the law requires that when considering a proposed decision, the board shall give great weight to the findings of fact by the administrative law judge. Now, you might give great weight to that, but disagree with the legal conclusions. And that's when, if you non-adopt it, the transcripts are received, the evidence is received, and you review it and reach your own legal conclusions. So after review and consideration, you vote to adopt the decision or hold it for discussion in the panel meetings. Now, I have an example to run through. And in this case, which is fictional, totally made up, we have a physician who was charged with gross negligence, repeated negligent acts, incompetence, and failure to maintain adequate and accurate medical records. And the facts are that this physician performed cosmetic surgery on 2 patients. For each patient, he failed to follow the standard of care to guard against infection, resulting in the need for additional surgical procedures. For each patient, he failed to document his actions and observations on post-op visits in the medical records. All causes of action were sustained by clear and convincing evidence to a reasonable degree of certainty. The discipline proposed is revocation, stayed, 3 years probation, with standard conditions and a medical record keeping course. Now, I'm sure many of you have the disciplinary guidelines memorized to a certain extent, and we know that this is a deviation from the disciplinary guidelines. For each of those things, the recommended penalty would be 5 years probation, plus there's a quality of care concern that is not addressed in the optional conditions. Only a medical record keeping course was in there. So a deviation may be justified, but it has to be established in the decision. Here, the justification was respondent has been practicing for 20 years and has had no prior discipline. His long history of practice without incident suggests competence such that no practice-related coursework above and beyond the normal CME is warranted. I would suggest to you that that is not a sufficient justification for not addressing the quality of care concern. Something may have changed during the course of that 20 years, and there needs to be rehabilitation of that physician with the quality of care concern. Also, it's not a justification for the 3 years probation versus 5. It's not explained. So this is an example of one that you may decide to hold to get the transcript to make that decision for yourself. In the end, you may find that it's appropriate, but it's not supported by the case proposed decision itself. So, with reviewing stipulations, you get a very similar start. You review the accusation, see what's charged, review the disciplinary guidelines, read the stipulation, but here you get a Deputy Attorney General memo, a DAG memo, that has additional information that talks about the strengths and weaknesses of the case. You determine whether the stipulation is within the guidelines for each allegation, and if it's not, does the DAG memo provide adequate justification for deviation? Still, you determine whether the stipulation provides sufficient consumer protection and, where possible, rehabilitation. And then you vote to adopt or hold the stipulation for discussion. And the question is, how can deviation from the guidelines ever be consistent with the board's consumer protection mission? And it's when, under the facts of that individual case, the stipulation provides sufficient discipline, which again, it's about consumer protection, and imposes rehabilitation measures and in a timely manner. There are factors that may warrant deviation from the disciplinary guidelines. These are just some of them. There's an innumerable number. So you consider the corrective actions already taken by the physician. Witness unavailability, witness credibility, dueling experts, and this is important because the burden is so high. Clear and convincing evidence. Expert credibility, the age of the violation. Remember, it could be 7 years from the date of the incident if the matter is not reported to the board until late. And sometimes that physician is practicing the whole time without any other incident, and it is something that comes into play. Value of more immediate discipline, and the level of certainty that discipline will be obtained at hearing. And I have an example that can demonstrate this. Again, this is a fictional case. It's based on the facts that I went over in the first example, but here it's just for one patient. There's 2 patients involved, but for one patient, he failed to document his actions and observations on the post-op visits in the medical records. Same charges. They're in negotiations, and he agrees that the complainant could prove a prima facie case establishing at least some of the charges alleged in the accusation. There's differing expert opinions on whether respondents' actions represent simple or extreme departures as to both patients. One patient has left the country with no intention of returning to testify. The second patient wants to testify but has significant credibility problems. Despite the lack of documentation in the medical records for one patient, respondent's nurse will testify that he followed appropriate post-op procedures in the care and treatment of both patients. And the nurse was very credible during her interview and is expected to testify well at the hearing. Respondent provided CME certificates to show that he has completed 20 hours in AMA-approved cosmetic surgery courses since the accusation was filed that relate to the practice deficiencies alleged in the care of these two patients. And there is a reasonable possibility that the administrative law judge could determine that only one negligent act was proven by clear and convincing evidence. The problem is what happens if the case goes to hearing and the administrative law judge finds that only one negligent act was proven by clear and convincing evidence, a simple negligent act. That case gets dismissed. There has to be repeated negligent acts for the board to take discipline. So, in this case, the discipline proposed was revocation, stayed 3 years probation, standard conditions, and the medical record keeping course. This is an example of what you all struggle with when you are considering what to do when you get something like this. There's a lot of things to consider, and there is a risk that some of these cases with repeated negligent acts can be dismissed without any discipline imposed at all. So the role of the stipulation, again, is you want to provide consumer protection, get the licensee disciplined, monitored, rehabilitated when appropriate, and you do it sooner without the delay and uncertainty of going to hearing. And with that, I'll take any questions that you have.
Thank you, Ms. Webb. Any questions to Ms. Webb? Dr. Lewis. Microphone.
Can't see it. Could you go please again about the writ and the possible outcomes and the advantage or disadvantage to the respondent or the medical board, and why, what's the advantage of them submitting a writ mandamus?
So, a physician who has been disciplined by the board can file a writ with the superior court to challenge that discipline and the bases therefore. And sometimes what happens is that the superior court judge will strike causes of action that the board has relied on to impose the discipline. An example may be that there's 3 bases for discipline, and the superior court judge may strike 2 of those 3 and send it back to the board to reconsider the penalty. In that case, it may change it from a 5-year probation to a 3-year probation to a public letter of reprimand. In other cases, the superior court may determine that the penalty is too harsh in light of the facts, it's arbitrary and capricious, and will strike the penalty rather than the cause of action. and send it back to the board to reconsider a penalty that's more appropriate. So that also delays the imposition of discipline, and the decision may be stayed during that time, in which case the monitoring is not occurring.
That can take some time
Yes.
before the Superior Court hears the case. I mean, prolonged time until it's on their calendar.
It can. These cases are given priority on their calendar, at least initially, especially if the physician is asking for a stay of the board's decision. But once the judge determines whether or not a stay will be imposed, if there's further hearings required, oftentimes that can take many, many months and sometimes years.
Thank you. Any other comments? So, Ms. Webb, what?
Dr. Yip.
Yeah, Dr. Yip, go ahead.
It's not exactly related to guideline, but the process that what is the revenue of appeal if the consumer was not satisfied with the outcome? Do they go through the medical board? Do they file a complaint? Or do we have an internal system that different panel look at the case or different dad look at the case? Is the revenue for the consumer to say, this is not what I think? Can you look at it again? What is the revenue now?
Internally with the board, consumers can ask when they get that closure letter to have the matter revisited, and if they have new evidence, they can share that. But it's after the fact. I know that some consumers have filed writs. I'm not aware of success. I'm sorry, not writs or civil litigation.
And really, at the point that the complaint comes to the medical board, then it's the medical board's complaint. And so it's, there's opportunity. The individuals will be interviewed during the process. But at the end of the day, what happens is the board's decision. And at that point, it's outside of the consumer entity. However, those individuals have the civil litigation side to go through. So it's two different issues. We're doing administrative, and then it's the board's complaint as to where civil is the civil penalty that you have from that side.
And in that respect, it's similar for criminal cases where it's the people of the state of California versus a defendant, and it's not that individual victim's case. And again, it's heart-wrenching, and it's very disturbing when it doesn't go the way that the victim wants. But it's the DA takes that case on behalf of the people of the state of California.
Dr. Cross.
Thank you, Ms. Webb. One of the things we've struggled with since I've been on this board, and probably for decades before, is this long timeline. We had an update even yesterday in terms of the tedious process that occurs in seeking discipline, and where the timeline may be too long. We continue to work to shorten that timeline. I think it would be helpful for you and Ms. Kirkmeyer to reiterate those components of the process that are not under the direct supervision of the medical board, because the public, rightly so, holds the medical board responsible, but yet on the other hand, the medical board is limited in terms of what part of the process we have the authority to directly control. So what is it which is not under our control?
There's a lot of moving parts to that. So the investigations are done through Department of Consumer Affairs Health Quality Investigation Unit. The Office of Administrative Hearings That's where our administrative law judges are housed. They set the hearing dates, and they're impacted, just like our civil courts are impacted, and our criminal courts. There are reasons that people ask for continuances of hearing. So, respondents' counsel can ask for continuance, and when it's appropriate, the Attorney General's office can ask for continuance. But it's something that delays the process every step along the way that the board isn't in control of. Additionally, even before that, getting the medical records from facilities or physicians can sometimes take time. And if there's a challenge, that may have to go through the subpoena enforcement process, and that can take many, many months to get through, because that's through the civil court.
The prosecution of the case also is outside of the medical board. It's actually housed with the Office of the Attorney General. So we do the upfront complaint part. We do the back-end processing to get it to you for vote. So what happens in between there is we're involved in, definitely, but it's definitely at other entities to get it to the end.
Thank you, Ms. Webb. The last thing what happens is it comes to the panel, and the panel decides, and depend upon the decision, the respondent still has appeals process. That's what you mentioned. My experience in all these years on the panel is that panel members, almost all the holds are the ones which were not approved, which comes to the in-person meeting, are for the increased discipline rather than decreased discipline, especially when it goes through ALJ. So it's a very difficult process. Then we are told by the attorneys that ALJ hears it for 4 days of hearing. That person has all the facts. We are looking for an hour or so reading through the material. Even then, many times, most of the times when we hold, actually it's for increased discipline. Thank you. Any other comments from the board? If not, comments from the audience? Let me see. Tammy Smith. Ms. Smith.
Thank you. Ms. Webb, your presentation was very good. And I feel if the board were really following those disciplinary guidelines as you shared, I wouldn't be here. The first slide, protection of the public shall be paramount. In my case against Dr. Hedrick, my complaint against Dr. Hedrick, the public is not being protected. The purpose of disciplinary guidelines: act as a deterrence. Your public reprimand of Dr. Hedrick will not deter him from changing his dangerous practice. The slide on stipulations saying a stipulation is a proposed settlement between the parties designed to avoid the delay. My case took over 4 years. Over 4 years. Talk about delay. I waited and waited for the board to take action, and still the action was unacceptable. On the slide, reviewing cases stipulations. Step 1, review the accusation, noting the allegations. Dr. Lewis, you signed off on this stipulation. I see he's gone. And I really would like Dr. Lewis to be here, because I want to know if Dr. Lewis even read the accusation Did he even review the allegations? If he had, I don't know how he could have come to the conclusion that a public reprimand was appropriate in a death case. And I'm sure if his child had been given 11 medications within a 6-hour period and then had been left to die a slow, miserable death, only to be found in rigor mortis, I highly doubt that Dr. Lewis would have thought that a public reprimand was an appropriate discipline. Step 6 on that same slide. Determine whether the stipulation provides sufficient consumer protection and, where possible, rehabilitation. In the case against Dr. Hedrick, there is no consumer protection and there is no rehabilitation. He can continue to practice as he has been practicing. He has not been, the board is not making him take classes to learn about the dangerous drug medications that he gave, about monitoring patients. So there is, again, no deterrence for him to change. And then the slide, the burning question. Under the facts of the case, the
Please
stipulation provides sufficient discipline and imposes rehabilitation in a timely manner. Again, no sufficient discipline, there was no rehabilitation, and 4 years is definitely not a timely manner. And that's why I'm here to confront you and to expose you, and I am going to fight to change this board so that consumer protection truly is paramount and not just a mission statement behind which you stand. Thank you.
Thank you. Any other comments from the audience? Yeah, Ms. Wright.
I've sat on this board since 2013, and I listen to the feedback that we get from members of the public. And I'm a public member. I know oftentimes the frustration is that there's doctors protecting other doctors. But if anyone's ever tuned into panel A and they've watched the line of questioning that I have, I'm usually very harsh, not only on our deputy attorney generals, but I'm very harsh on the doctor that kind of comes before us sometimes with almost an elitist attitude. Well, why should we even give you the license back? Besides the fact I'm a public member, I'm also a lawyer. And I can tell you that the reason these cases sometimes take so long, and I can even put it in my own experience, I have litigation that's sat on my desk for 4 years because the other lawyer will go through all these legal loopholes and jumps and delays, ex partes, and constantly waiting to go to trial. I have a case that the lawyer has gone to ex parte to prevent the trial 10 times. Last time he came in with his arm wrapped up in a bandage saying he fell off a ladder. Whatever. I want to convey to you and anybody else who's listening that we take this very seriously. We're not sitting here. There's lots of other things we can be doing. Public protection is really important to us. Unfortunately, a lot of us, and we're frustrated too, we sit in a system that is a lot of red tape. A lot. So the complaints that you have are so much bigger than the medical board. So much bigger than the individuals that sit here. I am particularly empathetic to you and anybody else that comes here and presents about a child who has died, a mother who's been killed, an auntie. It does bother me sometimes when I leave these meetings, hearing you. Sometimes, though, we are very limited in what we can say to you or anybody else, but please know that not only the doctor members, but the public members and our staff, you have no idea how hard we work to try to be fair. And in our panels, what do we do? So know that when you come here and when you're seeking justice, that sometimes it's so much bigger than the 12 individuals that you see sitting here and the holdups. I gave you an example. Supposed to go to a trial in June. He came in with his hand wrapped up because he fell off a ladder. I had been waiting and waiting and waiting. So trust us when we say public protection matters to us. I don't know how to say it any other way.
Thank you, Ms. Wright. you summarized a lot of frustrations of the board members. Any other comments from the audience? Comments on the phone?
Marianne Hollingworth, your line is open.
Thank you. Good morning. My name is Marianne Hollingsworth, and I am representing myself. I have some concerns and questions about the board's disciplinary guidelines. All too often, am I on?
Yes.
Okay, thank you. All too often, these recommended guidelines are completely disregarded. All too often, doctors found responsible for patient death through gross negligence are being allowed to plead down to public letters of reprimand. It didn't used to be this way. I'm going to cite real cases and not fictional ones. To compare current guidelines, I found a newsletter from 1996 where a doctor was given a public letter of reprimand for failing to tell the board he had received a citation for disturbing the peace and noise, basically for having a loud party. Another doctor received 10 years probation for having an affair with a former patient after he referred her to another practitioner. Now with these new updated guidelines, the disciplines are often more lenient. For example, the guidelines say any sexual misconduct carries a recommended minimum of 7 years probation. However, a doctor in Norco was recently given just 35 months for sexual misconduct with 4 female patients. The guidelines say gross negligence carries a minimum of 5 years probation. However, a doctor who was on the board of a prime healthcare hospital was found to be incompetent and lacking medical knowledge, yet he was allowed to plead down to a reprimand in the death of not 1 but 2 cardiac patients for gross negligence. These are not isolated cases. In the last newsletter, there were at least 5 cases where doctors were given public letters of reprimand where patients died. There have been at least 10 PLR cases over the last year, death cases. It's becoming the norm. I understand that the board is allowed to make exceptions in any case, but this is ridiculous. It's like someone robbing a bank and shooting a guard and then being able to plead down to running a red light in the getaway. You say board members are supposed to review guidelines and follow them when deciding on disciplines. Your bottom line is supposed to be public protection. However, more often than you like to admit, the discipline does not ensure public safety. Instead, it protects the doctor's practice and reputation. Why bother having the guidelines if you so egregiously ignore them? Remember, the board does have the final decision. My question for you is that how can you allow a simple public letter of reprimand in cases where the doctor has been found responsible for a death through gross negligence? That does not follow guidelines. Thank you.
Thank you. Any other comments?
Catalina Garza, your line is now open.
Hi, this is Shalina Garza. I have one question regarding the process that occurs when complaints go through the central complaint process, and there is a closure letter that is sent out to the complainant. When this screening is done by a physician, what is the reason why the letter cannot be more detailed instead of just providing the statute? Why can't the letter explain why the case is being closed?
Thank you, Kim. Thank you. And just to give you an answer rather than stop there, we're actually working on those letters. That's part of yesterday's what we did. So you might see difference in the letters coming through. We think it's inappropriate to send just a blank, blah letter without any details in it. Any other comments?
We have a comment from Eric Andrist. Your line is now open. Eric Andrist, your line is now open.
I find it highly amusing that the first slide in your presentation talks about public protection being paramount, in all caps with an exclamation point to boot. Your presentation isn't representative of what's happening in real life at all. That was just propaganda, and you're trying to pull the wool over the eyes of citizens. What a joke. It's interesting that an accused doctor can challenge the board with a writ, but victims have no avenue of appeal with the board at all. And Kim, I was never interviewed in my sister's case, and you closed my complaint based on almost no information. You didn't even get a secured copy of my sister's medical records on the first complaint. And Dr. Krause, it's my understanding that the medical board always has final say on a decision. They don't have to accept what the AG's office or the administrative law judges recommend. In the end, it always falls back on the board's decision. And Ms. Wright, it was your panel A that signed off on Dr. Hedrick's public reprimand in the Smith case. You are responsible. So how seriously did you take Dr. Hedrick's case? Our point is that fairness to patient safety isn't happening enough, and people are being harmed. I will illustrate shortly. The code section you quote says, whenever protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount and shall be the highest priority. But that's not really true, is it? It's at least not with the Medical Board of California. We can quote case after case after case where the protection of a bad doctor came at the safety of the public. In the case that I filed in the death of my sister, after settling a lawsuit against the doctor, this board closed my complaint twice without any investigation and without any explanation. There is no accountability for your actions. You can do anything you want without question, because when we file Public Record Act requests to check up on your actions, Carrie Webb, staff attorney, denies them illegally. Then when I ask the board to put the matter on the agenda for discussion, you just ignore it because you don't want to have to admit that she's breaking the law. The code also says, whenever possible, you're to take action that rehabilitates the doctor. Can someone please explain how giving the doctor who overdosed Tim and Tammy Smith's son to death a public reprimand is rehabilitation for the doctor, or even in the best interest of patient safety? Anyone? Here's a better example than Carrie's fictitious examples. Letter carrier Dennis Swang was fired by the U.S. Postal Service after his arrest on sexual assault charges. Assistant professor at UC Berkeley, Blake Wentworth, was fired on alleged sexual assault charges. The medical board filed an accusation against Dr. Adley Issa on December 11, 1998. In it, they accused him of sexual misconduct with 2 patients, gross and repeated acts of negligence with 4 others, incompetence, and violation of drug regulatory laws. 9 months later, he surrendered his license, but not permanently. In 2003, he filed for reinstatement of his license, and in 2008, the board granted his request, placing him on 5 years probation with terms and conditions. He then applied for early termination of his probation, and guess what? The medical board granted it. On April 21st, 2015, Medical Board Executive Director Kimberly Kirkmeyer filed another accusation against Issa.
Please conclude.
7 causes of discipline. On November 4th, Medical Board member Panel A Chair Jamie Wright signed a decision and order once again placing him. I am going to conclude. Again, placing him on probation, this time for 7 years. He got less probation time for his sexual assault charges 13 years earlier. Show us where these guidelines are doing anything at all.
Okay, any other comments?
Michelle Montserrat Ramos, your line is open.
Go ahead, please.
Good morning. This is Michelle Montserrat Ramos. California consumers and the board definitely have a conflict with your goal: consumer protection, not discipline. When a California patient dies in a hospital or a medical facility with no cause given for death or under unusual circumstances, consumers expect discipline for a physician. When Lloyd died, I had to hire a pathologist to find a cause for his death. In my complaint, I provided 2 autopsy reports, one from the Los Angeles County coroner. It included the doctor's arrest records, etc. As you know, Lloyd's complaint was closed at the Central Complaint Unit. You didn't find it worthy of investigation. There is nowhere else in the state of California where you can die and it will not be investigated. If you continue to promote that your goal is consumer protection, then you must investigate doctors in the case of California patients' deaths, and you must discipline. The only way I can see some of these numbers changing is by including consumers in the process. It is inadequate to file a complaint and have no means to respond before a complaint is closed. In criminal cases, the victim's family is included in the process. The reality is your priority is the rehabilitation of physicians, not consumer protection. A change has to be made. Include us in the process. Thank you.
Thank you. Any other comments?
Are there any other comments on the line?
There are no more comments on the line.
Okay, the next item is item 17, discussion on possible action recommendations from the Specialty Faculty Permit Review Committee. Dr. Bolad.
Okay. Thank you very much. The Special Faculty Permit Review Committee held a teleconference meeting on January 2nd, 2018. And at that time, the committee reviewed and discussed Dr. Per Richard Brenmark's application for a special faculty appointment with San Francisco School of Medicine. Please turn to BRD 17-1-2 in your meeting packet for a detailed report on Dr. Brenmark's medical school and postgraduate training. Dr. Brenmark specializes in the area of orthopedic osseointegration, specifically in the area of transdermal osseointegration, bone-anchored implants. Dr. Brenmark has held the position of president of the Orthopedic Surgical Osseointegration Society since 2007 and is a member of the International Society for Prosthetics and Orthotics. Dr. Brenmark has been awarded with the UCSF Presidential Chair Award, Brian and Joyce Blanchford Award for Amputation Research, and is considered an international expert in orthopedic osseointegration. Dr. Brenmark has performed several hundred osseointegration surgeries throughout the world, has articles published in top-ranking surgical and engineering journals, and is sought after nationally and internationally for his expertise regarding transdermal osseointegrated bone-anchored implants. If approved by the board, Dr. Brenmark will hold a full-time faculty appointment as a professor of clinical orthopedic surgery at UCSF. Dr. Brenmark will provide patient clinical care, teach and mentor residents and students in the Osseointegration Center at UCSF. Dr. Brenmark will also continue his research at the Defense Advanced Research Programs Agency located at UCSF. As of January 8th, 2018, Dr. Brenmark has held a facility registration at UCSF for 2 years, and the registration has been renewed until January 8th, 2019. Pursuant to Business and Professions Code Section 21681 Sub A5, an individual applying for a special facility permit shall not have held a position under Section 2113 for a period of 2 years or more preceding the date of the application. However, in this case, the board has the discretion in all cases to waive this requirement. At the time of the committee's meeting, we reviewed Dr. Brenmark's applications and qualifications and recommends that the board grant the waiver and approve Dr. Brenmark for a special faculty permit appointment. And that concludes my report. And are there any questions from the board? So with that, if there are no questions, I would make the following motion for the board. The board approved Dr. Brenmark for a Business and Professions Code Section 21681 Sub A 1B special faculty permit appointment at San Francisco School of Medicine and grant a waiver pursuant to Business and Professions Code Section 2168.1 A Sub 5. Do I have a motion?
Are there any questions from the members? Any questions from the audience members? Any questions on the phone?
There are no questions on the phone.
Ms. Cruz-Jones, can you take the roll?
Dr. Bolat?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Mr. Wormuth?
Aye.
Ms. Wright? Dr. Yip? And Dr. Gonadev.
Aye. Motion carries. The next agenda item is number 18, update, discussion, and possible action on the recommendations from the Midwifery Advisory Council meeting. Before I have Ms. Sperwan begin her presentation, I would like to take a moment to thank her. I heard you really doing something for her work on Midwifery Advisory Council. She has been on the council since the beginning, and her input, beginning of time, yeah. And her input into the issues and education of the members of the board has been invaluable. Ms. Perwan has stated that she will no longer be in the council after this term. We'll really miss you and miss the guidance you have provided to the council. Thank you for everything you've done. Please proceed.
Thank you. It's been my pleasure actually to be one of the original members of the Midwifery Advisory Council to the Medical Board. And actually even before that I was fairly active in providing midwifery guidance as a public member. I'm going to go on with midwifing sheep now, which this season turns out to be almost as challenging as midwifing women. So you've all read my report, I'm sure. I just wanted to point out a couple of things. The changes to the licensed midwife annual reporting tool that we've been working on primarily reflect changes that will allow us to improve on our data collection system and make it so that the data that's ultimately reported and included in your annual report is collected and reported in a way that really reflects what's actually happening in the community. And there were some glitches in how we'd been doing it before that we wanted to correct. And the other thing that I'm really excited about and look forward to getting approved is the community college program at American River College in Sacramento is continuing to go forward to create a program to educate both midwife assistants and licensed midwives. And it will be only the second community college program in the country to educate non-nurse midwives. And we're really excited to see that proceeding. What I need a motion for is approval of the following agenda items for the next MAC meeting in a couple months. An update on revisions to the licensed midwife annual report, update on the midwifery task force, including an update from the Senate on interested parties meetings related to that task force, and including, if relevant, update on regulatory efforts pursuant to Assembly Bill 1308. Update on hospital transfer form, update on the midwifery-related legislation, selection of new members to the MAC. There's one midwife position, my own, and one public position. A selection of a new chair for the MAC and vice chair. A discussion and possible adoption of term limits for members of the MAC. Update on a new program for midwife mentoring, which was started in Sacramento by one of the midwives there, and looks very promising. So we're looking forward to hearing more about that. Report from the chair, an update on the midwifery program, and another update on the community college licensed midwife program. So.
Boy, last meeting you were asking too much. Can we have a motion to approve? Okay, any discussion? Comments from the audience? Comments on the phone?
There are no comments on the phone.
Thank you. Roll call, please.
Dr. Bolat?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus? Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Mr. Warmoth?
Aye.
Ms. Wright? Dr. Yip? And Dr. Gonadev?
Aye. Motion carries. Thank you.
Thank you very much. And my term isn't up until June, so you will have to see me one more time at the April meeting. Thank you.
Okay, we'll skip 19 for now and get to number 20, the update from the Department of Consumer Affairs, Mr. Lay.
Good morning. President Gannon, Vice President Hines, Executive Officer Kirchmeier, members of the board. Well, first of all, Happy New Year, and thank you so much for this opportunity to allow me to provide an update from the Department of Consumer Affairs to your board. My name is Patrick Lay. I am one of the new Assistant Deputy Directors for Board and Bureau Services. I've been on the job for a whopping 8 weeks, so if you let me add a couple days, I think I will be able to call myself a true DCA department veteran. A little bit about myself. Prior to joining the department, I was the Assistant Chief of External Affairs at Cover California, the state's health benefit exchange. So I do feel among family member, at least extended family, healthcare family members, where I helped implement the Affordable Care Act since 2013. In those 5 years, I took a number of roles from operations to legislative and government affairs and stakeholder relations. And prior to that, I served in the California State Assembly, staffing issues under judiciary and veteran affairs. I do want to say it is such an honor to be here today and not only have this opportunity to work with you and your staff, but also learn more about the incredibly important work that you do protecting California consumers and California patients. With this, I will begin my update, which I will keep relatively short. The first item is the Directors' Quarterly Meeting. Later this month, on January 29th, the department will hold its Directors' Quarterly Meeting with board executive officers, bureau chiefs, and board presidents. And these quarterly meetings are an opportunity to ensure that Director Grafilo is available to you to hear issues that are important to the department and the various issues facing our various boards and bureaus. Particularly at this upcoming meeting, we will be covering issues of the DCA strategic plan and related action items that the department is hoping to achieve to further the department's mission and goals. The next items is regarding the DCA leadership training programs. At our last update, we provided some update on the department's future leadership development program, and our inaugural cohort is making successful steps forward. Our mentees, in addition to being paired with a mentor, are participating in special leadership development exercises. They're working on special projects that are furthering or possibly making good impacts on DCA, and they're developing new working relationships and meeting several executives who are sharing career advice. The FLD mentees will be meeting with Secretary Podesta from the California Business Consumer Services and Housing Agency later this January, and Appointment Secretary Mona Pasquille in February. My next update is regarding our executive brown bags. Our solid team has conducted a series of gatherings with board executive officers, bureau chiefs, and DCA executives. These structured social gatherings provide a forum for transferring knowledge, building trust, and establishing networking relationships. Our next gathering will be February 28th and will include a presentation on employee engagement as well as formal presentations on FLD's team projects. And my final update will be regarding required board member training. Dates for the 2018 Board Member Orientation Training, or BMOT for short, have been confirmed. The first one of the year is scheduled for March 21st. The next three will be on June 6th, September 18th, and December 5th. As you know, board members are required to take this training within 1 year of appointment and reappointment to a board. Registration, as always, is available online, and it is a one-day training in Sacramento, which details the important functions and responsibilities of board members. You can contact DCA's solid team if you are hoping to attend. As always, if there's anything that the department can do to help, feel free to contact me, and the Office of Board and Bureau Services is more than happy to help. Thank you very much.
Thank you, Mr. Lay. Any questions from board members? I'm just curious about those social gatherings. Anyway, any comments from the audience? Comments on the phone?
No comments on the phone.
Thank you.
Thank you very much.
Okay, so now we're back to 19. Item 19, presentation on the licensing outreach program. Ms. Toof. Microphone, Lisa.
This side of the table, it's on, sorry. I just have to speak up. Let's see. Which one of these? The right one? Gotcha. Okay. In 2001, I just wanted to give you a little bit of background on the licensing outreach program, how it came to be, and how it progressed into what it is today. In 2001, the board created a licensing educational program to build improved working relationships with California's teaching hospitals, the graduate medical education staff, and applicants who need a license to move forward with their postgraduate training and/or fellowship. This program has been expanded across all regions of the state, including all hospitals, private and public, and those governed by the University of California Office of the President. In 2009, the program, now referred to as the Licensing Outreach Program, was expanded to include hospital recruiters and credentialing staff in order to better explain the licensing process for those entities hiring faculty or other professional positions, with the intent to demystify the licensing process and to discuss how their anticipated hiring dates might best merge with the board's other obligations. About that same time, the program was broadened to include medical groups, community clinics, and health centers, etc. The program mainly functions through two avenues at the teaching hospitals. The first is participation in licensing workshops, and the second is presentations at resident orientations. When board staff is planning to be in a certain area, contact is made with the other nearby entities that could benefit, and visits to those multiple sites are included. In years past, the board has experienced a repeated backlog of physician and surgeon licensing applications during peak periods. These severe backlogs caused a plethora of phone calls and correspondence to be sent to the board. This backlog delayed physicians' ability to practice medicine and limited access to care for patients, which is in direct conflict, of course, of the board's mission. As you all know firsthand, hospital residents have lengthy and exhausting work-related obligations and oftentimes do not have the momentum to start the application process and submit the required documents in a timely manner. In addition to facing what probably feels to them like a surplus of paperwork, the residents have to take time out of their already busy schedules to get photos taken for the application, make an appointment to get their fingerprints scanned, as well as visit and pay for the services of a notary. These outreach events save the residents both time and money, since these events are kind of a one-stop shopping opportunity for applicants to complete many of these time-necessary steps all in one place. The hospital hires a notary, a mobile live scan fingerprinting service who are directly tied in with the DOJ, and a photographer, everything that is needed for the standard application process. If there are no unusual circumstances, residents can complete the entire paperwork process in less than 30 to 45 minutes. And that time frame also includes board staff going through the entire application, providing them with information on the other related forms to be completed and submitted by the medical schools, the postgraduate program directors, and the exam agencies. Also, with the convenience of having all the services provided at the licensing events, we are finding that many residents are applying earlier in the year, thus getting licensed earlier. Staff feels this can only be viewed as an advantage, not just for the operational needs of the board's licensing staff, but also for the mission of the board, a physician's ability to practice medicine, access to patient care, and ultimately consumer protection. As the outreach manager, I present at new resident orientations where I explain the board's mission, licensure requirements, deadlines, ramifications of failing to meet the licensing deadlines, and failure to disclose required information for medical licensure to the various stakeholders. I also explain how one event can make a significant difference in their licensure process, so they should not do anything that could jeopardize their license application process. The other thing that the licensing program has done is visit third and fourth year medical students. Both the chief of licensing and the executive director have attended these presentations. During this presentation, The licensure process is discussed, the board's website and online application process is highlighted, and the importance of a student's and residents' actions are explained. In addition, the board's laws and regulations, as well as some examples of areas where doctors get into trouble, is emphasized. Through my participation in licensing workshops, this same process is done on a one-on-one basis with each individual applicant to ensure that everything is filled out properly, no items are left blank, and all questions on the application have been answered. The purpose of this process is to ensure that errors or omissions are identified early and can be corrected at that time, instead of having to delay the process once the application is received at the board, and having those issues be added to a deficiency letter sent to the applicant. I can easily spend an entire day at a teaching hospital with these events, often starting as early as 7:30 in the morning and running as late to 6 or 7 p.m. The actual times are determined by the number of residents and the hospital's operating needs, with residents attending the events in shifts, oftentimes in between seeing patients or during their lunch and dinner breaks. An all-day 10-hour event can capture over 125 residents, which sadly only allows for a 3 to 5 minute consultation with each resident, as typically only one staff member attends these events. That'd be me. These licensing events are scheduled throughout the year and are often scheduled in the spring to try and capture those residents who are coming to the end of their first year of postgraduate training, for whom the hospitals are seeking licensure early in the following training year. Those scheduled in the fall try to capture those residents who have already completed their first year and now must be licensed by the end of their current training year. The process of reviewing applications before they are submitted and providing an explanation of what other training, educational, and/or related documents are needed, along with answering any questions the resident may have for the board, is preventative in nature and assists with keeping the errors seen in applications low. As you've seen in Ms. Kirkmeyer's licensing application statistics in each of the licensing program summaries, this program has assisted in eliminating spikes in the applications received. In addition, this program has been justified by the comments and praise received from the long-term GME staff at the hospitals, who have stated they have seen a significant drop in errors and problems since the program began. A reminder email is sent out in early December to the GME coordinators, training hospitals, and program directors, reminding them of this service that the board provides. Several events have already been put on calendar for the 2018 calendar year, with still more to come. That is the end of my report, if anybody has any questions.
Any questions from the board? Yeah, Dr. Hawkins.
Nice to see you again, Lisa. I heard you say a bad day may include 125 residents. How many a year, or what are the interval you want to give does this program reach?
It does vary, and it depends on several different issues. I can actually get you a total number of how many I met with last year, since it's only my first year into it. But I can give you a number. I can get you a number for the total amount for the year that I've been doing it. I just don't have it right here. Is it about 300? I guess she says, yeah. So, but I can get you an exact number if you'd like.
Anybody else? Dr. Cross.
For the physician members of the board who often have affiliations with medical schools, could you be in touch with us directly to see how we may be able to assist in terms of getting you in, so to speak?
Absolutely, I would love that.
So that our impact can be improved?
Please, that would be wonderful. Absolutely.
Thank you.
Thank you.
Yeah, I think in spite of all this, we get calls that somebody did not apply in time and they can't go to the next year. It's a huge issue, and these kids, they're extremely busy. They make mistakes, and the program directors, they realize it in the last second. Right. And the bigger issue is I often face is the PTAL letters. I don't know how many calls we get on PTAL letters, but thank God that's going away, right, Kim? So that will relieve some of the burden on the licensing. And as I mentioned yesterday, I think our most efficient department is the licensing. So congratulations, and continue to do the job well done.
Thank you.
Any comments from the audience? Comments on the phone?
We have a comment from Shalina Garza. Your line is open.
Go ahead, please.
This is Shalina Garza. I have 3 questions. The first question is, there was a foreign medical or international medical graduate liaison division previously that seems to have disappeared, and I would like to know what happened to that division. They were very helpful previously. It just seems to disappear. The second question is, why does California have this PTAL letter instead of a resident physician training license like every other state does? Why does California have to be so different? What is the purpose of this PTAL letter rather than just a resident training license? And the third question is, Business and Professions Code 2096 requires a 4-month general medicine training for every resident, and I need to know what the intent of that 4-month requirement is, and has the board considered its impact on other specialties such as pathology?
Actually, I'll have you talk to our licensing staff. I think a couple of things you mentioned were not correct. PTAL is going away, so it's better to really talk to either Lisa or April. So we'll leave you. They will be happy to take your call. Thank you, though. Any other comments on the phone?
No other comments.
Thank you. Thank you, Lisa. Thank you, April. Okay, so this one, right? So moving on to agenda item 21, presentation on the Center for Health Quality within the California Department of Public Health. I would like to ask Ms. Christ to come forward. Ms. Christ, thank you. She is the Chief Deputy Director of Policy and Programs at the Department of Public Health and has an extensive background in the healthcare arena. Her full bio can be found under the agenda item 2021. We're glad she could join today and provide the information on her unit. Ms. Christ.
Does it work now?
Yeah.
Perfect. Thanks for having me here today. And the purpose of my being here today at your request is to talk a little bit, give a little bit of an overview of the Center for Healthcare Quality, what they do, what they don't do, and then also talk a little bit about opportunities that Kimberly Kirkman and I had discussed, where we, the California Department of Public Health, and you see potential opportunity for better collaboration or coordination as it relates to our regulatory enforcement. So while the slide presentation is coming up, I just wanted to let you know that so the Center for Healthcare Quality is one of the 5 centers that I'm responsible for. Unfortunately, the deputy director herself of that center is unable to be here today, so you drew the short straw. You got her boss. So if there are any very technical questions, I'm going to have to defer and get back to you on those. But I think I should be able to cover most everything that we wanted to talk about today. So Center for Healthcare Quality has 2 specific areas. One is the regulatory function in licensing and certification for over 30 types of healthcare facilities, and also certification for several healthcare professions such as CNAs, home health dialysis technicians, and also we license the long-term care administrators. We also have some responsibility for approving certain types of healthcare worker training programs, and then we conduct criminal background checks in conjunction with the individual professionals that we certify. And then we, as part of the other part of the program is actually the Healthcare Acquired Associated Infections program, and that is You're all very familiar with that. HAI is obviously happening in the healthcare facilities, with the focus being acute care in hospitals, but with the help of the members, and this is a statutorily created program, with the members of those HAI committee members also looking at expanding into more the long-term care setting. I'm going to start singing and dancing in addition to this, just to be a little bit more. That's perfect. And plus, this is not really reading the slides, it's more of a conversation. I apologize that I'm going to turn my head back and forth just to make contact with you. But just some statistics. I mentioned over 30 types of healthcare facilities. That is about 10,000 or so in the state of California. As far as complaints that we receive, as well as what's called entity reported incidents, which is when something happens at healthcare facilities, they are required to report unusual occurrences and ERIs, as we call them. That total is about 42,000 a year that we get to investigate, triage and investigate. And then as far as the volume on the medical professionals, the staff, there are about 200,000 certified nurse assistants, home health aides, and certified hemodialysis technicians that we certify. And we also have responsibility for certifying the respective continuing education providers. So those are the major areas. It's one regulatory aspect of the Center for Healthcare Quality and one non-regulatory, which is the HAI program. So going just to the regulatory part of the house, which is the licensing and certification area division, they wear two hats. One is the state hat, state licensing hat. So there are state licensing requirements. They go in, they do the state licensing, relicensing surveys, and they do complaint investigations associated with anything related to state requirements. Then they also wear a federal hat. So they also go in, and we get a grant from the federal government, Centers for Medicare and Medicaid Services. We get money to conduct the CMS part of the house, which is the certification side. And what that means for the facilities is that it's one thing to have a license, but in order for the money to flow from Medicare and Medicaid, you also need to have certification. And so there's separate requirements that we then go in and do the certification visits and recertification visits. Oh, I can now forward. You're awesome. You're good. I can't believe the executive director is advancing my slides. That's amazing. You guys are awesome. I'll come back. So fieldwork wise, as far as the licensing and certification area, the way that they're divided up is geographically throughout the state of California, lots of healthcare facilities, so 14 district offices, and then we contract separately with Los Angeles County to conduct that business on our behalf, or a piece of it. They don't have the full scope of everything, and they're divided up into 4 Los Angeles County district offices, so in total 18 offices. And then we also look into things like medical breaches, which is just one type of incident, as you can imagine, when protected healthcare information is disclosed when it should not have been. So on the enforcement side, we have various tools, one on the state side and one on the federal side, and the two sometimes mix and sometimes don't. But one of the things that we can do is issue deficiencies requiring facility plans of corrections. That is a very common occurrence because it's really hard to go in and look at any sort of an audit of any type and not find something, and that is tied into state requirements or federal requirements. Then there's the state citations that we can issue that may or may not have monetary penalties associated with those. We can revoke state licensure. That's doesn't happen very often, but we certainly can. We can also recommend to the federal government federal civil monetary penalties. Medicare, Medicaid, they can actually hold money back or prevent people getting paid for additional admissions if it's something really bad. And then we can also recommend federal enforcement remedies such as decertifications or denials of payment for new admissions. Some of the things that are outside of our jurisdiction, there are many things that are not within our jurisdiction, but just thinking about what is in our jurisdiction is state facility licensing requirements, on the facility side as well as the federal side. That's pretty much it. So when we go out to do surveys, that's what we look for. Is there any violation against any of those requirements? However, so in general, we don't have jurisdiction over physician-owned ambulatory surgical centers unless, of course, they're certified by CMS, in which case we do the certification survey. Professionals licensed by yourselves and other boards. Myself, I'm a nurse, so I'm not licensed by CDPH either. By our colleague back there, I guess. Urgent care centers that are not licensed as primary care clinics is another example. And then just in general, since this is a topic of interest, the Business and Professional Code 805, we don't really have jurisdiction over, but there is certainly a connection between the work that we do. One of the areas that Kimberly and I had discussed where we really see a better opportunity to work more closely together is when the board's responsibility, the medical board's responsibility, and CDPH's responsibility may bleed into each other. But we may not be aware of an incident that we should be looking into because it was reported to the medical board and maybe vice versa. And I actually spoke to one of our the physicians we employ that do the surveys, we call them medical consultants, but they're state employees. And I know Dr. Otto has been here in the past, but he's no longer with us, and we're recruiting for a new physician leader if anybody's interested, putting it out to the public. I spoke to one of our informal leaders who was amazing, and he shared with me a lot of the potential opportunities, and one of them is because we have 14 district offices plus our contractor Los Angeles County, how consistent are we in reporting things to the medical board when they should be reported from us to the medical board? I think there's an opportunity there to work together and really make sure that as we have that physician leader in place, we have those folks come together in a forum and really talk about that in consultation with the medical board. So one of the things Kimberly and I talked about is really bringing our teams together and doing a meet and greet and maybe do a regular get together to talk about opportunities and things that we're finding. So that's something we're going to do moving forward, which we're excited about. The other thing is that, 805 or not, but we can take action against a facility when the facility knew of physician misconduct or incompetency, yet failed to implement their policy and procedures to address the problem. That is failure, could actually be a violation. Again, it's very dependent on the individual incident, but of federal regulations regarding a facility's governing body and medical staff bylaws, Title 22, there are lots of different opportunities. It just depends on the situation, and I think there's lots of opportunity to work more closely together and look at opportunities to cross-refer things to each other. Same thing, if something is reported to the medical board, don't assume the facilities has taken care of it on the administrative side. We should probably figure out a way to hardwire some of that referral process as well. And so that's something I think that will be our focus for this coming year, so we're excited about that. Another area that we see collaboration and opportunity in is working with each other on items that that our medical consultants see when they go out to, for example, to those ambulatory surgery centers that are certified, that we do have to go out to, where we see things that we know are may not be a violation of the areas that we have anything to do with, but they may be a tag and they may be something that you're interested in as well. They could be more boring things, yet very important things, such as ASC's understanding of the reappraisal process and the staff privileging process is one area that we see opportunities. We think that where there's a better understanding required, and our medical consultants do what they can on their end while they're there, but we feel that the medical board may not be aware of some of these issues. You may be, but you may not be aware of some of the things that we see. And again, a great opportunity for us to get together and say, here's what we're seeing when we're out there. Just wanted you to be aware, and then have some of the cross-referral opportunity. And also, as it relates to your memos, which, by the way, we want to commend you to a memo that you issued in December, I believe, on the the unusual occurrence event reporting. Our medical consultants who got a hold of that letter were very excited that that was issued. So things like that. We also have a way to issue things that we usually do as it relates to our own standards that we have to enforce, but it's called an all facilities letter. And we're working right now with Kimberly to actually finalize and issue an all facilities letter regarding 805. So even though we do not literally enforce that, it is very important and it is the law. And it is something that happens in the facilities that we have jurisdiction over. So we're going to work together to issue that AFL to help facilities remember about 805. So, and thanks, by the way, for a draft that was sent to us. We're working it into our format, and you'll get to see it before it goes out. So, yeah. Then I wanted to share a couple of exciting things with you. I thought this is pretty exciting already, that we'll be working closely together. But I think the other areas is something new, and I think the public members that are in this room and on the phone might be interested in. We just now launched in January a new website called Cal Health Find. There's an old site that used to be called HCFIS that was really hard to use. What Cal Health Find enables the public to do, or really anyone, it's a really great source of information for healthcare consumers and providers. They can search for facilities by name, facility type, or location. They can view those health facility provider details, including ownership, licensing and certification status, whether they accept Medicare or Medi-Cal, performance by history, complaints, entity, facility reported incidents, state enforcement actions, deficiencies identified by our staff. They can compare up to 3 facilities at a time and file a complaint electronically. So that's something new and very much improved, and we hope the public and people will be able to benefit from that. We also just redesigned on the non-regulatory side our healthcare associated infections report. It used to be very well, there's still lots of words in it, but let's just say there are lots. The way that we display data now is much more friendly for people to actually see how we're doing and performing. And I know that many of you are physicians and would be interested in seeing how we're performing as a state as it relates to HAIs. And that's a new and revamped and very exciting report that we issue every single year, and we just issued the latest one. So that's available as well. And then we continue to advance in our electronic ability to do GIS mapping. And on the HAI side, that's something that is becoming more and more advanced. What that actually helps, besides informing the public, what that's helpful with as well is also for our HAI team to identify opportunities for regional consortiums, since so many types of providers or healthcare facilities share the same patients. You go from acute care to long-term care to home health to back to, you go in and around the system and you share the bugs. And so there's opportunities, and as a result of some of this, working with the local health jurisdictions and the healthcare facilities to actually come together and say, hey, what can we do? We're sharing these patients. What can we do to help fight these HAIs and do a better job? So we're very excited about that as well. I know this is not what I was asked to present, but this is a bonus. And then for contact, we wanted to list here for you. Deputy Director is Gina Icino, Assistant Deputy Director Scott Vivona, and then we have chiefs of the various areas. There is a one-stop shop number. If you dial this number, 916-324-6630, you should be able to get to either one of those folks if they're in the office. If not, they will get back to you. And with that, I would like to open it for any questions you have.
Thank you, Ms. Christine. Dr. Cross.
Thank you so much. I appreciate your being here, and you give me cause for optimism. I read an article in the LA Times a few months ago, and the reporter noted that he had called the California Department of Public Health about a incident, and the response of the California Department of Public Health was, we're not investigating it because we haven't received a complaint. I think that when we see something on one side, we have to recognize that there may be multiple agencies, multiple boards, multiple facilities that should have knowledge of it. And then when we share information, that should automatically become a complaint worthy of investigation. And in an effort to be more collaborative, I think we need to sit together and think of every way that that can occur. I'm not sure if I go to the Medical Board of California's website, if there's a menu that the public can click on to properly direct them from that website to a link to the California Department of Public Health or to a link to another board. We're very eager to tell people that you're contacting the wrong board, you're contacting the wrong agency, you need to speak to so-and-so. But if we can better serve the public with whomever they call, with a direct link to the appropriate agency, I think that will be better for the public and better for all of us. So thank you for being here today and for helping us find better ways of protecting the public.
Sounds like a wonderful opportunity. We look forward to working with the board. Thank you.
Thank you. Dr. Bola.
Yes, thank you very much for being here today. And Dr. Krause's comment, I know myself, having called various agencies, not yours in particular, but the idea that as a public agency serving our healthcare consumers, kind of people knowing everybody's business at least at a superficial level enough that they can refer people, I think is critical, because we are complicated in California for sure. In terms of the health care associated infections, I thought I heard you say that for the long-term care facilities, you're going to be working soon to be addressing those issues, or did I misunderstand?
Yes, we are trying to figure out how to utilize the limited resources we have for an HAI program that is very much focused on the acute side right now, to see how we can translate that into the long-term care side. We have to be kind of creative of how we address that, because that is something that right now we're addressing. Again, it's not regulatory, it's something that we actually do with consultations. One thing the board could actually help us with is, as you can imagine, when the HAI people call facilities and say, hey, you're not doing so good on your HAIs, let us help come in. They say, who are you with? We say CDPH. They say, nope, thank you, because they think we're the regulatory side of the house. And so this is actually free consultation with people that are experts for their folks that are working in infection control. And this is an area also of opportunity for us.
Yeah, no, and thank you very much, because for those of us that are practicing physicians, those are on the board of practicing physicians, it is not an uncommon situation at 11 p.m. on a Friday that the individual from a skilled nursing facility is admitted with urosepsis, for example, or a HCAP. So that I think those issues are really important, and your idea of having regionalization. I happen to work at UCLA, and one of our colleagues in geriatrics has really spearheaded this, and I think the role of public universities in healthcare and all of our boards is to raise the level of care to our healthcare consumers. So the more I think that those groups can follow up and look at natural migrations of our local patients, I think is really important. So thank you very much.
Thank you. Any other comments from the board? I just want to make thank you for coming anyway. And I think for the past few years, especially since Kim came as the executive director, we're trying to connect with all the other agencies which are involved with healthcare, pharmacy board, CDPH, and so on. So this way, we get a global perspective of health of California consumers. Wonderful. Thanks again. Yeah, Kim.
Just yesterday we had a item that came up for our strategic plan. Actually, someone else brought it up to us, but was talking about mandated reporters, as you may all remember. And so this all facilities letter that's going to be going out from CDPH to all of the general acute care hospitals, that's going to really help us in that strategic plan already, because that's going to go out. We put a lot of information in there about 805s. The whole goal of it was to talk about 805.01s, because that's where we see individuals not reporting. And now we're doing the penalties on that, but we use that opportunity to kind of throw the kitchen sink in there and say, all of these have to be reported, and don't forget, there's 805 and 805.01. So it'll be interesting to me to see what happens after we've done that, because we haven't really done an all facilities letter on this item for a long time. So this will be great working together.
Make sure to staff the phones once that goes out.
Any comments from the audience? Comments on the phone?
No comments on the phone.
Thank you.
Thank you.
Okay, now going to item 22, update and the Enforcement Committee, Dr. Yip.
Thank you. Yesterday's Enforcement Committee meeting, Ms. Dow provided an enforcement program update. She provides statistical information regarding the volume of complaints investigated by the board staff, the Department of Consumer Affairs Health Quality Investigation Unit, and the Health Quality Enforcement Section from the Attorney General's Office, and the current time frames to complete complaint investigations. Even though the number of complaints received during fiscal year 2016-2017 has increased from prior fiscal years, most enforcement programs have reduced the time it takes to investigate and adjudicate complaints. Ms. Dove also provided an update regarding what enhancement the board has implemented to improve the investigation of 805 and 805.01 complaints. Specifically, educational letters have been sent to 22 entities that are required to submit the mandate report because the report either lacked sufficient information to investigate the complaint or the report was submitted late. In addition, board staff has prepared 61 subpoenas for records to assist HQIU with its investigation of this complaint, which has helped reduce the overall case investigation timeframe. Expert review training is also scheduled to take place at USC Medical School on September 22nd to 2018, and the board staff is actively securing locations for additional training to be held in San Diego area and possibly Sacramento for September and October 2018. I attended the Enforcement Collaboration meeting held in Sacramento January 8, 2018. The meeting was attended by Board Executive and Program Management and Executive Management from HQIU and HQES and Deputy Attorney General's Office too. During the meeting, several enforcement matters were discussed to include the process of medical exceptions and unlicensed complaints, parallel prosecution cases, and general case processing issues. The collaboration by all was genuine and wonderful, and the meeting was beneficial to all parties. Finally, Commander Mr. Hecklin from HQIU and Supervising Deputy Attorney General Mr. Davis from HQES gave a very informative presentation yesterday regarding the vertical enforcement field investigation process. The presentation really demonstrated all the phases involved with investigating complaints and the efforts of the investigators and the prosecuting attorneys to ensure the complaints are investigated thoroughly. This concludes the committee update. Thank you.
Thank you, Dr. Yip. Any questions, comments to Dr. Yip from the board? Comments from the audience? Comments on the phone?
We have a comment from Eric Andrus. Your line is open.
Between Dr. Yip's thick accent and the bad sound system, I'm not sure what he said. I'll just say that in the end, it doesn't matter how you get to a decision. It matters whether you've protected the citizens of this state. If your procedures aren't accomplishing that, you should be working to change the procedures. You should be asking yourselves in each and every case, regardless of what the AG's office or the ALJs recommend, whether following their lead is truly going to be in the name of patient safety. Giving Dr. Daniel Hedrick a public reprimand does not accomplish that. And we can cite hundreds of cases now in the same vein. To the contrary, we can actually prove that you are almost always leaning toward just accepting the recommendations which either protect the doctor or get the complaint off of your desks as quickly as possible. And I see that the cameraman is now zooming in on the medical board sign now so that we can't see the medical board's reaction. You've become complacent and derelict in your duties, no matter how much you want to ignore the signs and pat yourselves on the back. Ms. Wright tried to pass the buck in her explanation to the SMICs when she sat on the panel that gave Dr. Hedrick a public reprimand. For shame, Ms. Wright. Dr. Lewis signed the order. Tammy Smick brought up a great question. Did Dr. Lewis even bother to read the original accusation, or did he just skim the documents and accept what the AG's office was recommending? And why did this go to Panel A in the first place when the executive director usually signs off on such things? Did Kimberly Kirkmeyer want no part of the brouhaha it was going to cause if they let this negligent doctor off the hook with a slap on the wrist? It's all very suspect. It's also very suspect that you all sit there and ignore us and our pleas and never make an attempt to meet with us and try to make this board better based on your input. It's also very suspect that there's never a patient safety advocate that actually sits on the board. I guess the doctor members are afraid they won't be able to control them like they do the other public members. Whistleblowers came forward in 1993 to expose that the medical board was throwing legitimate complaints in the trash. Let's hope that someday more brave and caring people will do so again. Stay tuned to NBC News and other news outlets for a report on today's meeting. Thank you.
Any other comments?
No other comments on the phone.
Thank you. We'll go to the item 23, moving to the Vertical Enforcement Program update from Ms. Castro.
Good morning. Thank you very much, as always, for the opportunity to report to you. We very much appreciated being able to present some of the investigatory functions that the Health Quality Enforcement and Health Quality Investigation Unit perform on your behalf on a daily basis on over 1,700 cases. We invite the full board to definitely take a review of enforcement 6 from the Enforcement Committee, and also watch the webcast. I believe that Mr. Andrew Hagelin, a supervising commander, and supervising Deputy Attorney General Matt Davis did an excellent job to be able to try and explain what is a very difficult and arduous kind of in-depth process. I'm happy to report that Miss Mary Kane Simon has joined the Attorney General's Office San Francisco unit as a supervising deputy attorney general. She comes to us with a lot of experience in administrative mandates and profound experience with civil litigation in every single aspect. So we know that this recent hire will most definitely protect the public and further your mission of the medical board. At the same time, I'd like to announce that we have 2 new lead prosecutors assigned to your important mission. Ms. Michaela Mangardi is a Deputy Attorney General in San Francisco, and she is known to the board already as she has been working very closely the last 6 months with our Chief of Enforcement, Christina Delp, on 805 issues and 805.01 letters of instruction, and to be able to beef up that important process that is part of your mandate. At the same time, we also have appointed Jansen Tan to start the Sacramento lead prosecutor position in February. Mr. Tan comes with a lot of victories on your behalf and writs and appeals, and a very high record of revocations and a lot of suspension orders. And so we're excited to have him join our lead prosecutor team at a good juncture in our program. I'd like to thank Ms. Lynn Dombrowski for her service as a lead prosecutor in San Jose. And I wanted to let you know that Ms. Nichols and I continue to work in every aspect on timelines and improvement to processes, as well as engaging in a very robust case disposition review with Ms. Delp, your Chief of Enforcement. And with that, that concludes my vertical enforcement report.
Thank you, Ms. Castro. Any questions to Ms. Castro from the board? Comments? Oh, you're getting away easy, huh? Any comments from the audience? Comments on the phone?
No comments on the phone.
Thank you. Gloria, next one, please.
Yes, sir. So we don't have much of an update for the Attorney General's office other than to say that we did comply with Business and Professions Code Section 312.2, which requires an annual Attorney General report on its representation of all Department of Consumer Affairs clients. This is posted on our website and has been provided to Ms. Kirchmeyer and Ms. Lawley.
Thank you. Again, any comments, questions? Comments from the audience? Comments on the phone?
No comments on the phone.
Thank you, Ms. Castro.
Thank you. It's a privilege and honor to represent you on a daily basis.
Thank you. Okay, next one is item 25, vertical enforcement program update from the HQIU. Ms. Nichols and Mr. Hegelin.
Yes, good morning. Kathleen Nichols, Deputy Chief Health Quality Investigation Unit. I would like to introduce you to Northern Area Commander Andrew Hegline. Andrew oversees the Northern HQIU field offices located in Sacramento, Concord, San Jose, and Fresno. He has worked and supervised medical board cases for 21 years. Andrew gave a joint presentation yesterday with members of the Attorney General's Office to the Enforcement Committee regarding our investigation process, and he will be presenting our HQIU update today.
Hello. I am pleased to report that HQIU has 7 sworn investigators starting in January 2018, and that 6 of the 7 currently possess their post-basic certificate, so will not require an academy. These 7 are filling positions in our San Jose, Rancho Cucamonga, Cerritos, San Diego, Valencia, and San Dimas field offices. With the newly hired staff, there are currently 23 investigator vacancies, which is a 30% vacancy rate. We have 25 sworn HQIU candidates in background. We now have 19 limited-term special investigators working in the HQIU field offices to assist with workload. I'm also happy to report that DOI has been granted priority status with CalHR for the psychological and medical portion of the background, so candidates are completing the background process more expeditiously. In December, HQIU completed a 3-week mini training academy for new investigators. Positive feedback was received, and we plan to hold the similar trainings in the fall of 2018. Our current closed case average for the last month was 530 days, which includes an average of 18 days for the medical board and the Attorney General's office to disposition the case. This is a high number and reflects that as our staffing levels rise, we are closing some of the older cases that aged due to the vacancies. We always prioritize our caseloads to work the cases that present the greatest threat to the public first. So there are some cases that have received less attention due to the nature of the allegations. As we become fully staffed, this number will reduce, and our goal is to have every case investigated in a year or less. Reduced caseloads will also positively impact the age case average. The HQIU sworn staff also currently have a high percentage of overprescribing cases. These cases are complex and take longer to investigate. Multiple patients are involved, and in some cases, multiple undercover operations are needed. As of December 14th, 2017, 30% of all sworn cases involved allegations of overprescribing. HQIU attended an enforcement meeting on January 8th with the Enforcement Committee Chair, Dr. Yip, Medical Board staff, and Attorney General staff. A new process was approved for the frontline review of overprescribing cases that will consist of the entire cures report being reviewed by an expert who can assess if there are concerns and identify patients before the case is sent to the field office. This will improve timelines for these cases, and we look forward to its implementation. That concludes our update. We'd be happy to answer any questions you may have.
Thank you for your comments. I take it for granted that our timelines will be decreasing. Is that correct?
Yes.
Okay, thank you. I'm hoping that before I get off this chair, we would have started to cut down the timelines. It's 4 years in going, so any comments from the board? Yeah, Dr. Bolan.
Yeah, thank you very much. I know that we have a war on opioids, and I realize that what our former Surgeon General put together, and a lot of what was not reported is being reported with respect to opioids. My specific question is, when your physician is looking at these cases, do you have a report that talks about the milligram morphine equivalent doses? That, in other words, if somebody's on 900 versus 200, for opioids by themselves, if you withdraw, you don't die. You'll be miserable, but you won't die. And then are you collecting data that says I'm looking at the milligram morphine equivalents of opioids, but I'm also looking at the other concomitant prescriptions associated, such as the benzodiazepines. And if that's the case, it would be really nice for us to see that. That will help us, I think, understand, because if you're putting a lot of energy and effort into this, I can understand that. But those quality of care issues obviously are huge too. So I appreciate any reports that you might have.
Yes, those are taken into consideration by not just the medical consultant, but when it goes out to the expert to do the final review and report, those things are taken into consideration and commented on the reports.
Specifically, if you have those reports, it would be nice for us to see what kind of cases are coming to you. Are they the people that that somebody's the individual reporting because the person's getting 100 milligram morphine equivalents a day, or is it the 900? So just understanding that variation would be important.
Thank you, Ms. Castro.
Yes, there is a tool available in Cures 2.0 that would measure the MEDs. It's an analytical tool. It's one that our staff does utilize in the prosecution level after we have filed the case, but it is also something that would be available if it's something that would shortcut the pill counting and really to assess how much is this patient getting at any time. Of course, it's an ex post. It's a better tool used by physicians, but it is available to us off of the Cures.
Thank you. Any other, Dr. Yip?
Are the medical consultants employed by your unit now?
Yes.
So how many altogether that would work for the medical board cases?
I believe we have approximately around 23 right now, and we are in the process of hiring more, especially for the Fresno office. We'll be conducting interviews within the next several weeks.
And do you have like chief medical officer that oversee the program, the qualification, double check if they did the best? Because yesterday we heard the whole process. They are actually the most key person. They have the authority to say yes, go, no, don't need the investigator. So they have a very important role that will make sure the quality, make sure they're really doing the best job they have.
Yes, there are minimum qualifications to be a consultant, and also those exams are scored and they are ranked. And then in addition to that, we hold the interview panels where we discuss extensively their past peer review experience and what type of experience they've had reviewing quality of care cases in their field.
And they're full-time, right?
They are part-time. They're considered permanent intermittent. Most consultants work 1 day a week or 2 days a week in a field office.
So I want to clarify, because I think there's some confusion here between language of our doctors. So the medical consultants that they're talking about, the 23 that are in the field offices, those are the ones that are actually the ones that work with the investigator. When the case goes out to them, they look at the case as well. They help them conduct the interview. They answer questions for the investigator, technical questions. They're the ones that really work with them and put the package together for that physician interview. And correct me as I go along if you want to throw in more detail, Andrew and Kathleen. But that's what that group is. Those are state employees, and they do work for the HQIU office, and that's what their role is. They do not say whether the case goes forward or not, though. They may, in some very minor cases, look at it and say, we don't think there's enough evidence to go on here, but that's a very limited role. What we were talking about yesterday and what everybody's talking about is our expert reviewer program, and that is actually under the medical board, and there's about 1,900 individuals. Is that right? No, about 900. That was off by 1,000 or so. About 900 individuals, almost 1,000 individuals on that list, and those are actually kind of with everybody. First of all, they're not employees of the medical board. They're independent consultants, and they work with the investigators. The investigators are ones that reach out to them after there's discussion between the AG's office and HQIU on who it should be. The investigator reaches out to them during the course of the prosecution. The AG's office reaches out and talks to them as well. So while they communicate with those individuals, then they also could hear from the medical board, because then we also give them reviews, and that's one thing Ms. Delp is working on, is giving feedback to the expert on their review. So that's the individual that actually reviews all of the information the expert or the medical records, the interview, and anything else that has been put together in the investigation report and opines on that case. And that's the group, I believe, correct me if I'm wrong, Dr. Yip, that's the group that we were talking about yesterday that really holds the key on the case, as well as our upfront individuals in the central complaint unit. Okay.
Thank you, Ms. Kirschmeyer. Any other comments from the board? Comments from the audience? Comments on the phone?
No comments on the phone.
Thank you. Thank you both. So as I mentioned, so we'll be seeing the timelines go down, right, Kathleen? Okay. Okay. Moving to agenda item 26. Makes me happy. Agenda items for April 2018 meeting in Los Angeles. Both. Dr. Krause. Yeah.
Thank you. As follow-up to our discussion about potential updates in paramedic triage, I'd very much appreciate if we could have a presentation about sobering centers and a presentation about mental health acute care centers. Additionally, I think the board and our staff deserve to hear from someone from the Attorney General's office, specifically in reference to board harassment. If a patient is disruptive in my office, haranguing the staff, the patient is cared for, but the patient is discharged from the practice. I am aggrieved when our staff are threatened, harangued, harassed, demeaned, and diminished. And I think it's appropriate for someone of appropriate legal background and authority to have us understand what the board's obligations are and what the board's limitations are. I would like to have that addressed.
Thank you, Dr. Cross. Any other items from the board? From the audience? I'm sorry. Dr. Bollard, go ahead.
Sorry, I apologize. I wanted to follow up on something, with cannabis being much is now legal. We're going to have individuals that are going to be in transplant, be it stem cell, and I would like an expert or someone to be able to discuss this issue because, again, I know that tobacco, when someone's smoking and they're waiting a heart transplant, they need to not be smoking. But just the issue of cannabis and that how that is going to impact individuals that are on transplant and stem cells. So that may not be able to make it for this board, but I think it's something that we're going to have to look at because cannabis is going to be showing up everywhere and we're going to be looking at it and it could be causing potential delays in patient care and a misunderstanding even though we have great guidelines. I think the knowledge of cases and the impact of cannabis is not yet fully known by the average clinician.
Okay. Thank you, Dr. Bola. If it doesn't make it to the next meeting, I'm sure it will make it to one of the meetings. Any comments from the audience? Comments on the phone?
We have a comment from Eric Andrist. Your line is open.
I'll bet you'll all be really glad that you closed the complaint against the doctor who killed my disabled sister and didn't list his malpractice settlement, which misleads the public into thinking he has no malpractice settlements, and now have to deal with me at every meeting for the remainder of your tenures, huh? I assume Dr. Krause is talking about me. You can blame my attendance, Dr. Krause, on the demeanor of the people and my demeanor on the people who mishandled my complaint and refused to follow the law. Had they done right by me, I wouldn't even be here. It'll be interesting if your agenda item goes up before mine because I've asked now, this will be the 6th time that I'm asking for the Public Records Act to go on the agenda for the April meeting. And I will continue to ask for it until you do put it on the agenda. And we'll point out each and every time the mass number of times you've refused to deal with this important First Amendment and patient safety issue. Your defiance in not putting it on the agenda really just goes to show that you don't want to admit that you're wrong and that your staff attorney, Carrie Webb, is breaking the law in order to protect the medical board. If you were truly right, you'd have no problem discussing it. And finally, it was awfully big and professional of Staff Attorney Carrie Webb to admit she was wrong cutting people off before 3 minutes during public comment in the October meeting and apologizing for it. Oh wait, she never acknowledged or apologized. She doesn't seem to have the ability to understand that she's ever wrong. And Dr. Krause, it's a First Amendment right to be able to call into a public meeting and speak our minds on topics that are related to this medical board. So good luck.
Any other comments on the phone?
We have a comment from Marion Hollingsworth. Your line is open.
Hello, this is Marion Hollingsworth. I would like you to please have an agenda item on the next LA meeting to discuss and vote on requiring doctors on probation for sexual misconduct to notify their patients. This in light of the Me Too and Time's Up movements. Thank you.
Any other comments on the phone?
No more comments on the phone.
Thank you. And as the business is done, this meeting is adjourned. Thank you.